It's social distancing at the chamber, something we call happy hour with Hammer. As always, we are joined by the CEO of the Arizona Chamber, Glenn Hammer. My name is Garrick Taylor. Glenn, we've had some great guests on this show, but you and I are giddy for today's guest. We've been hoping to get this guy on for a while, so why don't you introduce our special guest?
Well, it's a real treat because we always love having our special guest in Arizona. He's moved the meter and has helped reshape Arizona's tort reform environment for the better, big time. But today we're joined from the nation's capital by Harold Kim, who serves as the president of the U.S. Chamber Institute for Legal Reform, which I believe may be it's one of the nation's largest law firms. If it were taken as a law firm by itself, I believe it's one of the top ones for sure. And he's responsible for providing strategy, policy guidance, programmatic management, and leadership support for ILR's comprehensive program aimed at improving the nation's litigation situation. And we are joined by probably the person in the country who has had more wins in our 50 states and nationally than any other human being when it comes to improving our legal environment over at least the last decade or so. Harold Kim, welcome to the program.
Hey, Glenn, thanks a lot for having me. And I got to say, I'm giddy as well to participate with you guys on this issue.
And I know that our outstanding state treasurer, Kimberly Yee, who worked on some of the tort reform bills with Harold Kim, I know she's going to watch the show. And it reminds me, we need to book her as a guest because she's doing some great stuff through this pandemic as well.
Well, shout out to Kimberly. Hope she's doing well.
No, thank you. So you have pretty much right now, the 50 state chambers united around the need for litigation reform on the federal and state level. Specifically, we'll talk about public nuisance in another show if
Sure.
The show gets the ratings we need to still be on the air post COVID-19. But right now, it seems that the most important issue on the policy side is getting the litigation parameters properly set on both the federal and state levels with respect to this deadly disease. Could you talk a little bit about that, Harold?
Look, Glenn, I've been doing legal reform for nearly 20 years now, and I have never seen a groundswell of concern about the liabilities that are going to emerge out of the coronavirus outbreak. It doesn't really matter if you're a Fortune 500 business or a coffee shop in downtown Phoenix. I mean, these are real issues. And the fear and the concern and the cloud of liability is something that policymakers in Washington, but also all throughout the country, are taking a really close look at because it's a huge, huge issue as the country starts to reopen and restart the economy moving forward.
Could we break this down a little bit? Leader McConnell has made it very clear this is a red line issue for the majority party in the United States Senate. Maybe we'll start on the federal side, the different pieces that need to be in place.
Sure. Well, so as you said, Leader McConnell has basically laid down the gauntlet. About 2 weeks ago, he said any other funding to the states as part of this phase 4 package has to have parallel accompanied liability reforms. And he has been very clear about this, whether on the Sunday news shows to the floor of the Senate. I think he's got his caucus rallied behind him on this, in addition to the administration. I mean, Steve Mnuchin, or Secretary Mnuchin, was on Fox News Sunday with Chris Wallace, and he basically reiterated this red line. And so, you know how Washington works and how this process is going to move, headed forward. I mean, the Democrats in the House, Nancy Pelosi, they'll send over a House bill for about $3 trillion in spending as early as today. The Senate leadership on the Republican side has basically said it's dead on arrival. We've got to get into a thoughtful discussion. And when it comes to the liability issues, it's really at the top of the list.
So as the Senate grapples with the liability issue, and by the way, in the $3 trillion package, is there anything useful on the liability reform side?
No, we are very very conscientious of what that product's going to look like, and if anything, it may have anti-legal reform measures that actually expand liability. So,
okay, so a good thing it's DOA. But so
Yeah, I think we've identified 4 major issues, but it's certainly not the exclusive set of issues. You know, as companies are considering the risks of opening or how to open and how to protect your employees, a lot of different issues are popping up. But I think the 4 core pillars, as I put it, is what you've identified. There are exposure issues, whether you're an employer with employees who may claim that you didn't take reasonable precautions to safeguard them from the coronavirus. But it's also for a restaurant that hosts customers or third parties. You know, what is that standard of care? So that's, in a lot of ways, one of the big ticket items that the Senate is looking at. You identified product liability when it comes to extending protections for manufacturers of additional countermeasures like hand sanitizers, or the coverage of individuals or companies who are voluntarily providing PPE that doesn't have current protections under federal law, which should be expanded. You want to encourage more of these protective measures out there. Third is medical liability. There really should be a focus on protecting the frontline healthcare workers. We've certainly seen a number of states, and frankly, on a bipartisan basis, you know, governors in places like New York, Illinois, and Michigan issuing executive orders extending these types of protections. And then the 4th area, which is more uniquely federal than anything else, is the anticipated flood of securities class action lawsuits, because the stock market has taken a beating. And you can imagine that there are going to be a lot of different claims from class action security lawyers saying that a company did X, Y, or Z in response to the coronavirus that somehow now created a stock drop. And so, you know, those are the areas. But look, there are other very specific employer-employee related issues, like, you know, when it comes to discrimination claims. You know, if you were asking for a vulnerable population to stay at home, and if they're elderly, what does that mean for ADA or Fair Labor Standards Act types of matters? And then there are issues of data privacy, you know, with tracing and all of these issues. And so, you know, this is a very complicated area that we are trying to navigate in terms of how we are listening to all the input from state chambers like yourself and you know, other places in the country, but also practitioners and our members.
The prospects of some bipartisan support in the United States Senate, what's the latest?
Well, we had a Senate Judiciary Committee hearing a couple of days ago, which was your first expose in terms of how the political parties are going to position on this. I think my general observations is that the Republican side of the aisle seem pretty much coalesced on the message of the importance of having legal reforms. I think the Democratic side of the ledger have expressed skepticism in terms of the litigation threat. They focused a lot of the discussion on whether this is even necessary, given causation standards and that there are existing protections. I mean, arguments we've heard before in the tort reform battles in the past. But I think the point to make here, Glenn, is that this really should not be a partisan issue. If you look at what happened post 9/11, you had the enactment of the Safety Act, or, you know, some of these major disasters in the past, like the Y2K crisis that was looming in 1999. I mean, a bipartisan Congress passed liability protections. And so, you know, the things that we're focused on doing in Washington, and as we talk to great state partners like yourself, is to look for reforms that are timely, because it's got to happen quickly. This can't happen over the course of the next 5 years. It'll be too late. They have to be targeted so that they're narrow enough and they're tailored enough to address the solutions, and they have to be temporary so that it responds to the COVID-19 crisis, so that, you know, this is, so that it's an area that's appealing, it's reasonable, and something that should get strong bipartisan majorities. And the only thing I would add is we issued a poll last week from Public Opinion Strategies, and this is by Bill McInturff, who does the NBC Wall Street. And it showed that over 6 in 10 Americans said, hey, liability protections are things that Congress should be doing. And then when you drill down into those numbers, like 84% of the respondents, so I think it was a sample size of like 700 or 800 people, said that for essential businesses that are currently open, they should receive liability protections. And for the non-essential businesses that are going to reopen, that number was at 82%. And this was a big coalition of Republican voters, Democratic voters and independent voters. So, it's clear to us that this message is resonating, the fears are there, and that Congress has the public support to do something on this front.
Well, Bill McIntyre, for those watching, is the Babe Ruth of polling. So he calls it the way the numbers come out. That's really important. My final question on this federal level before I turn it to Garrick is, some will say, well, are you just saying we could allow bad actors to run rampant?
Right.
That's not what we're talking about, but can maybe get into that argument a little bit?
Yeah, let me talk about the proposal on what we're trying to do on the exposure side of things. What we are encouraging Congress to enact at the federal level is a safe harbor for companies to receive liability protections if they follow CDC and or state or local guidance when it comes to social distancing, when it comes to protective equipment. And it's important that companies and businesses and even churches and, children's care centers and, charities, that they know what the standard of care is moving forward. And if you have that standard of care, you shouldn't be subject to a negligence lawsuit. We've also called for exceptions to recklessness, willful misconduct, and gross negligence. And so, again, to my earlier point that the solutions have to be tailored, I think this is something that legislators from both sides of the aisle should really gravitate towards, because, it responds precisely to the type of certainty that businesses are going to need when making these decisions on the risks that they're going to be looking at from liability.
And Garrick, please fire away.
Maybe we can talk a little bit about the things that state lawmakers ought to be thinking about in this age. But Harold, maybe you could give a little civics lesson for us, for this non-lawyers here. You're pursuing reforms, what we just discussed, reforms at the federal level.
Right.
Does that only affect the federal court system? And could somebody, an enterprising trial lawyer, use the state court system? Maybe talk a little bit about that.
So I think the best way to describe the response from the federal government and the state governments is an all hands on deck approach. And what I mean by that is that the federal legislation would set a federal standard that could affect state law with a preemptive effect under the supremacy clause of the US Constitution. So the federal legislation would preempt state laws, but it would effectively create a floor, so that if states want to build additional liability protections on top of the federal standard, then the state law would prevail under those circumstances. And we've already seen a number of states like Utah, North Carolina. I think there's a bill moving in Oklahoma. There are a number of other states, state legislatures, Louisiana, that are looking at moving legal reforms in the wake of COVID-19. And so, it's a complement, to ensure that these liability concerns are addressed, from coast to coast. And if certain states want to go even further, they should be able to do that.
And should state lawmakers, like those at our capital in Arizona, should we be looking in those same buckets: exposure, product liability, medical liability, and securities?
It's a good start, but it's certainly not exclusive. I mean, I think it was Louis Brandeis back in 1932 who said that the states are laboratories of democracy. And so every state, they make policy decisions based upon the unique characteristics of that particular state and the economy in that state. It may be mostly a rural area or an agricultural area. And so, those policy decisions, are customized and stylized in terms of what the solutions are. What I will say is that we've been working with the Arizona Chamber and other state chambers and in-state civil justice groups to provide, policy suggestions and to help our state partners really appreciate and understand what's happening in other states, so that do they know what the tactics of the plaintiff's lawyers are? Because we get to see that, from a 30,000 foot level, but also what are best practices and what types of solutions have actually worked in the past. And so, that's how we see our role. I mean, you guys are the pros in Arizona, and you make things happen. And so we look at our relationship as a strong partnership, so that we can collaborate and coordinate and give you at least, our viewpoints and some content that we see from other states.
Well, you've been just a great help, and sometimes literally have come on the ground here to get some very important measures over the line. Is there anything that stands out in the Utah and North Carolina proposals that we should be specific, especially looking at as we move forward on the state level here?
Well, those two bills definitely addressed exposure claims. And I think the Oklahoma legislation that's moving through the process is doing the same. But there was also a premium on the healthcare workers. And so, and the proposals are relatively similar. You know, you've got a safe harbor if you follow CDC guidance or state and local guidance. And so, you know, the model seems to be aligned with what's being discussed in Washington. And again, when you look at North Carolina, a Democratic governor signed legislation passed by a Republican legislature. Mm-hmm. Same thing happened in Kentucky, you know? And so, you know, there's a lot of good model legislation to look at and executive orders as well.
Well, what I think is really important here is as our economy in Arizona has been re-energizing, and the governor here, Governor Ducey, is a great you know, supporter of civil justice reform, you know, has by executive order done some things for Good Samaritan laws and on the healthcare side, is that, you know, businesses want to protect their employees and their customers. They are voraciously reading anything that comes out of the CDC or State Department of Health or you name, or industry, just best practices from you know, different sorts of trade associations, you name it.
Yeah.
I mean, it's in our interest. I mean, to build a consumer confidence, you need to have that safe place. However, this is a however. We're still dealing with a global pandemic with no great cures, a lot of progress being made, but no great cures, and no vaccine at the moment. So there's just going to be for the foreseeable future, there's just going to be an increased risk to every activity. I mean, even opening the door and getting something that's delivered, it's not, there's just nothing out there at this point in time that's risk-free, unless you're like in Antarctica.
Well, I think this all speaks to the uncertainty. I mean, what's going to happen? I mean, there's no playbook for any of this. And you see the CDC guidelines. I mean, they change constantly. You know, before you didn't have to wear masks. Now you should be wearing masks. And I think it's an evolution as we learn more about this disease, its effects, you know, on the human anatomy, and, you know, how contagious is it? How is it transmitted? And so, you know, I think that there's the economic piece of this, which is aligned with, very importantly, with keeping the workplace and customers safe, which is of paramount importance to all of the members who we are talking about and talking to. So, you know, those are the most significant issues as the country looks to reopen.
Yeah, I really believe if this is done right, this is really part of the solution in terms of not just economic health, but physical health, because by creating that safe harbor and encouraging good behavior, you're going to have safer workplaces and safer places for customers to visit.
Yep, that's right. I mean, you want to over-incentivize compliance, right? And if you
exactly
could safe harbor, then that's another aspect to it, because, you know, companies want to do it anyway, but they have that litigation uncertainty. And if you eliminate that by saying, here, be super compliant and in good faith, then you shouldn't be sued.
Well said.
Awesome. Harold, the work that you and ILR are doing is so critically important. We can tell you that from the perspective of the Arizona Chamber, we have surveyed businesses, large and small, inside and outside our membership. And as you can imagine, liquidity is a major concern, but right there at 1A of their concerns list is whether they're about to walk into a legal minefield as they reopen their business. And so we just want to thank you and ILR for the partners that you've been in putting forth good recommendations and good policy solutions in this very fraught time.
Well, thanks a lot for having me, guys. I really appreciate it. I always have a special place in my heart for Arizona and Phoenix. I grew up in Vegas, so I'm a desert rat, and love connecting with you guys.
Well, we look forward to having you back in Arizona in the not too distant future, Harold. And thank you for all of your great work and the great work of your team.
Thank you for the partnership, Glenn. Thank you, Garrick.